everyone. I will call this session of the Supreme Court to order. This is the calendar for Tuesday, November 17th, 2020. I will simply ask everyone order to just note your appearances. I will then call the first case, which will be the Farrelly matter. Anyone else who is not on that case can excuse yourself with the camera and your audio, of course. You can monitor it, and we'll follow the order of the calendar. So if you, after this, we will then go to the Turnbull matters, and then we will go to Xavier, and then Wall Fresh. So what we will do is we will call each case, each have 15 minutes. We are going to allow you 3 minutes in the beginning to state your case without interruption. After 3 minutes, then questions will commence. You will indicate at the beginning how much time you wish to reserve for rebuttal, the appellants, and that will be subtracted from your 15 minutes, and you will reserve that for rebuttal. So with that, each one, if you just indicate who is present. I see myself, Justice Swan, and designated Justice Gomes Carty, who will be the justices on this case. Justice Cabret is recused, so she is standing by for the rest of the calendar. So starting with Clive, if you would indicate your appearance, and then we'll just go down the calendar.
Good morning, Chief Justice. Good morning, other justices and colleagues. This is Clive Rivers. I know I think it says Ateem Abraham, that's an associate in my office. However, we had a little problem with our laptop, and this is the one I'm using.
Oh, I wish we could correct that, because everyone in the world is going to think that you are Abraham.
Okay, let's see if we could get it fixed, Justice. In the meantime, I'm the second case, so we'll see if we get it fixed before then.
Okay, very well.
All right.
Senator Lawrence?
Good morning, Your Honor. I'm sorry. Go ahead.
Good morning, Your Honor, Chief Justice and other justices. Attorney Rhea Lawrence, on behalf of Ms. Palermo in case number 2020-0012.
Okay.
Good morning, Your Honor. Attorney Azad A. Winter, on behalf of Mr. Farrelly, present in my office, and all justices also, including Judge Swan, who I haven't seen for quite a while. Yeah. Aside from that, I have in my office the guardian, Ms. Quinones, and I have in my office also my son, who does most of my computer work. Thank you.
Thank you.
Good morning, Your Honor. Ronald Wilson on behalf of Dennis Farrelly.
Okay, thank you.
Good morning, Chief Justice. This is Tom Alcon, and I represent Clement Xavier in his appeal.
Thank you.
Good morning, Your Honor. This is Attorney Rob Kaczynski on behalf of the appellee and defendant Treasure Bay Corporation, doing business as DV Carina Bay.
Thank you.
Good morning, Chief Justice. Michael Sheasley on behalf of World Fresh Market. My co-counsel Dwyer Arce is going to be doing the argument today, and he messaged me that he is waiting to be admitted into this hearing. So, and I re-forwarded him the link as well.
Very well. Okay, I think that's everyone. Anna, Attorney Paiwanski.
Good morning, Chief Justice. Good morning, Justice Swan. Good morning, Judge Carty, Anna Paiwanski, on behalf of the appellee, Naomi Turnbull, as successor trustee of Kenneth Turnbull Senior Revocable Trust. Present.
Very well. Thank you all. And again, we will now formally turn to the matter in re the guardianship of Ivan Farrelly. And this is civil number 71 of 2018. Attorney Russell and Attorney Winter. So Attorney Russell, for the appellants, you may proceed. Would you
Yes,
indicate?
I'd like to resolve 6 minutes.
Very well.
Thank you.
Let's see if we get the clock to start the clock at 9 minutes. Okay, you may proceed.
Thank you, Your Honor, and good morning to Your Honors, Carty and Swan, and good morning to everybody who is listening and viewing. This appeal involves what is the priority set in the Virgin Islands Code for assigning a guardian
Something wrong.
Well, Russell, it looked like you're frozen.
I lost connection and I lost video for about 10 seconds there, Your Honor. Could you hear me?
No, we could not.
Yes, I can hear you now.
Hear you now, but we couldn't hear you for a while, so you can.
Okay, I'll start again. And the priorities of the code, and I'm arguing why Dennis Farrelly should have been appointed as a guardian here. The priorities of the code, section 5-310, clearly has the putative spouse as number 4. And anybody who having a power of attorney that's appointed by the ward himself gets priority over the putative spouse. Because there's a lot of acts here that are very, very troubling to the family of Mr. Farrelly, okay? And Ivan Farrelly have 7 children. And what has happened is when Ms. Quinones got involved, she stopped the children from visiting him, having any contact with him, or being involved with him. And to add insult to injury, she married Mr. Farrelly after he had been diagnosed with Alzheimer's. And the doctor testified that he couldn't make decisions, important decisions for his life, and he should be appointed a guardian. And despite findings, medical findings, Ms. Quinones stated that she married to Mr. Farrelly while this action was pending. That's highly suspect, Your Honors.
Did you raise the issue of competency at the trial court?
Yes. Yes. And I raised it initially when attorney.
Did you raise that he wasn't competent to marry?
Yes, I did. It's in the record. And I also raised the issue that he wasn't competent to hire an attorney. At the outset of the matter, Your Honor, we raised the issue that he wasn't competent to hire an attorney and the court should appoint an attorney. The court had an appointed attorney and relieved that attorney of the responsibility of representing Mr. Farrelly and said that they would accept Mr. Farrelly hiring attorney Winter. We objected to that from the beginning because we believe that the court should have appointed an attorney independent of Attorney Winter and independent of Ms. Quinones. And the reason why is because Ms. Quinones, as the family saw it, was the problem, and she shouldn't have her attorney representing Mr. Farrelly also. And we raised that at the incident.
Who did Attorney Winter represent?
He represented both of them, Ms. Quinones and Mr. Farrelly, and we objected to that. And the court, whatever decisions the court made, I think created more problems with this case.
Why didn't the court appoint? Why didn't the
that
court appoint a visitor in this case?
I don't know, Your Honor. We strenuously objected to having Ms. Attorney Winter represent Mr. Farrelly, especially since he was representing Ms. Quinones.
My question is, why didn't the court appoint a visitor as the statute requires?
We asked the court several questions. We couldn't figure out why the court didn't do that.
But didn't the court ask you both to address that issue, and neither of you did?
The court asked. I thought we did. I thought we did by suggesting that his brother or any another independent person could represent him. When the court interacted with Ms. Farrelly and us, the court, I think, made some mistakes by, first of all, continuing in the matter, not having the hearing to determine his competence. Second of all, requiring that all of his children be present for that competency hearing, which was wrong, because he didn't need to have the children present. And then the court, unbeknownst to Mr. Farrelly's children and the people that were going to testify for him, could continue the matter. And that's created a length of time that has added to the problems in this case. Now, let me ask you.
I want to fire Attorney Russell.
Attorney Russell, you have to, the background is a little bit more than that. There's a long-standing dispute between the set of children that Mr. Farrelly had. I think it was 5 of them. And with Ms. Quinones, his wife. Here is someone he was married to before, and she contended that they break up the marriage because these same children was going to Mr. Farrelly and giving him rumors about her infidelity. So they finally divorced the first time. He's about 29 years older than her. After the divorce now, some years later, even when his brother was in charge, he was seen apparently all over the place in many bars drinking. His son, Junior, who came from the States, and when he saw what he deemed to be the deplorable condition that his father was in, the only person that he could have turned to was the ex-wife. Well, when she came into the picture, apparently she started to take care of him. At this time, Denise, the daughter, is off island getting treatment for medical something. But hold on, attorney. So, you know, we got to be very clear, because apparently here's a woman that he married a second time because he loved the treatment she had given him the first time, and she looked after his welfare. That is, to me, is huge. Not necessarily which family could take care of him.
Your Honor.
Yes.
Ms. Quinones' testimony is highly suspect, and you're reciting Ms. Quinones' testimony.
Well,
and that
is
is
highly suspect in one way.
Because she had an interest in controlling Mr. Farrelly because he just received a lump sum of money, and she had an interest in getting access to the money and getting control of him outside of his family.
Well, why the testimony that the daughter who was in charge of him apparently there's some allegation of more than $200,000 missing. And the ones and they
That's
said
an
and the
allegation.
testimony says that when the money went into the account, when she had this power of attorney, she was withdrawing it almost the same day.
That testimony is unsubstantiated and it's just testimony to go against Dennis Farrelly. The truth is, he had.
Well, it is testimony that the court heard and the court under oath, so the court could consider it.
The court could consider it, but the court didn't take into account the myriad of situations where Mr. Farrelly was put out of his house twice, how Ms. Quinones dealt with Mr. Farrelly, and how Ms. Quinones kept Mr. Farrelly away
during
from
the first marriage,
the family.
Because, as she contended, that it was a domestic violence case because he was listening to rumors by these same children.
No, Your Honor, she has a narrative that is in her own interest and is highly suspect. And I don't know how the judge could even accept it as truthful, because she was dishonest during the trial with several things, and that dishonesty inured to Dennis Farrelly's detriment. Think of it. Think of it. His entire family, all his children, want to get in touch with him. His friends, his brother, and Miss Quinones is keeping them away from him. There is a reason that occurred. There is a reason Miss Quinones took Mr. Farrelly when his brother was taking care of him, when Dennis Farrelly was off island, and moved him in secretly with her. She says he agreed to everything, but he was not competent to agree to anything. And they will have control of the faculties.
Attorney Russell, what about Ivan Jr.'s testimony with respect to the fact that in 2015, his father appeared to be undernourished, malnourished, not being taken care of. There was no food in the refrigerator, obviously no care. And then a year later, he comes back, and even with his blessings of remarrying the ex-wife, Ms. Quinones, a year later, he comes back and he notices his father is doing a whole lot better. Doesn't that account for something, Attorney Russell? Nowhere in the record does it show where you showed, and you're saying that she's dishonest now, but nowhere at any point in time in the record did you show that she was unfit, that Ms. Quinones was unfit, or that somehow she was neglecting him or abusing him, or show that he did not improve under her care.
Okay, Your Honor, the emergency petition was filed. The court delayed this matter unreasonably. And the children sort of realized that the court wasn't helping them. And when the hearing was held, half of my witnesses couldn't attend, because we had witnesses on the 17th of July to address an emergency hearing. Attorney Winter filed a motion. We objected to it, that this is an emergency, and the witnesses weren't available a year and a half later. And the reason why they weren't available, they themselves, his family members, all his siblings, not his siblings, his children,
live abroad,
brother, and everybody. Yeah, some of them are abroad. Some as his friends is here. Mrs. Gore is here. The reality of it is that they sort of didn't appear because the hearing had already been tainted, as they saw it, by the order issued by the court. I didn't try to discredit Ms. Quinones. I went on the law, and she had a power of attorney. And while the son came down to testify against the family, that son is not part of the family with the sisters that existed when they signed the consent and waiver. We had consent and waivers that Denise was suitable. Okay.
Well,
The issue is
what happened, Mr. Russell? Because you're not addressing when the daughter, I believe it's Denise, had to leave the island for months. It might have exceeded a year or something, and he was just there floundering because they left his brother in charge of him.
okay.
But the testimony
Let me
is
answer
that
that.
she
Let
was
me answer
off
that.
island. She got medical issues, and that his wife, current wife, former ex-wife, that he seems to get along with, that he seems to like, she'd
No,
have been
Your
treated
Honor,
him according to the testimony. Then,
yeah.
why should she not be given priority? Because the
Absolutely
daughter
not.
that was taking care of him
Absolutely
is
not.
dead, and there's an
I thought,
accusation against her
Absolutely not.
of her taking
Because
money from
she has estranged the entire family.
yeah, Attorney Russell,
Yeah.
you can save that for your rebuttal because you
Okay.
you expired all of your time.
Thank you.
Attorney Winter.
Good morning again, justices. I
Just
would like,
a minute. Let's set the clock at 15 minutes. Okay, you may proceed.
okay. Your Honor, this matter, if Attorney Russell is relying solely on priority, is governed by Title 15, Section 5-310. If you look at that section, Your Honor, Denise would be a daughter or a child. When you look at it, subject to subsection C, the court in appointing guardian shall consider person otherwise qualified in the following order of priority. And it goes 1, 2. When you go to 3, it goes to who had a durable power of attorney, or I would also concede power of attorney. When you're dealing with mental disease, no one psychologist, or we had 2, can tell when it started. So what goes for the argument made by Attorney Russell that my client might not have been competent at the time she married that Mr. Farrelly was not competent at the time she remarried Quinones, it goes as to whether he was competent to execute documents given whether it's a general power of attorney or a durable power of attorney for healthcare purposes, because he is not arguing that the priority that she would receive is number 5, because she would be below number 4, which a wife has a higher priority than an adult child. He is now saying that because she had a power of attorney, that it boosts her up. I submit to you that that is false, because there is no documentation that I have presented or can present, and Attorney Russell can present, as to the state of mind of Mr. Farrelly at the time he executed those documents, or at the time he remarried Quinones. Thank you, Judge, with that. Now, I want to point out incorrect in the record that Attorney Russell failed to point out to this court. Mr. Farrelly married is Ina Rogers and one with Iola Roberts. Iola Roberts and my client, Mr. Farrelly, bought property together. And Mr. Farrelly Jr. is the son of Iola Roberts. The record is abundantly clear that property, because Farrelly and Iola Roberts owned the property jointly, they could only transfer their part to the children. At this present time, the property is owned by the children of Ina Roberts Ina Rogers, and also by Iola Roberts. Now, that is significant because I want to make sure the record is corrected. Now, when Mr. Farrelly married Quinones, she has no children for him. They have no children together. There was a disparity in age, but older men tend to facilitate towards younger women. And she was a beautiful, is a beautiful young woman, and they got married. Now, there were problems in the marriage.
Yeah, but let's go back to the guardianship, because that's really all that we are concerned with.
Okay.
The petition was filed by Denise, and at the time that she filed the petition, there was in fact the medical determinations that he was compromised. Is that correct?
That's correct, Your Honor.
Yes, yes, that's correct.
Okay. Now, I want to go back to the visit to the visitor, because it seems to me that the court did not follow the law in this case. You know, granted, there was a new law that was implemented in 2016, but this new Guardianship Act requires that the court set a hearing and appoint a visitor, and that visitor has specific responsibilities, including interviewing the respondent to determine the respondent's views about the proposed guardian, explaining the nature of the petition and its effects, informing the respondent of his right to a lawyer and the fact that his estate would have to pay for that lawyer, and must interview the proposed guardian, visit the respondent's dwelling, produce a written report to the court with recommendations regarding the appropriateness of the guardianship. In this case, that was not done. And I want to know, what is the authority? I gather the court indicated that it was not necessary because it was not a request for a conservatorship, but I believe that the court misread that provision, because here there was no request for a conservatorship, and if the court doesn't appoint the visitor, which is required, and this is a uniform law in most cases says that is a requirement, and having waited a year and a half, why should we not remand it so that the court can actually follow the law?
No, that is a very honestly question that it would have been nice for me to have had an opportunity.
Well, the court requested that both of you brief it.
Okay.
And none of you did. And the court went ahead and decided, well, she was not going to, because of whether it wasn't a request for a conservatorship, which it was not, and that he was in fact represented by a lawyer.
And that is the problem, Judge, is because it is my position at that time that Attorney Russell did not want to have Attorney Ezard A. Winter fighting him in this case.
Okay, well then let's go to that. Who was your client in this case?
I have represented both parties over the years, Your Honor. I know Mr. Farrelly. I don't know if you realize, but he's a brother of our late Governor Farrelly. And Ms. Quinones grew up across the street from where I live, where my mother's house still is. And I have represented them both. I was not involved in the divorce, but for example, I can go to a bar, Mr. Farrelly, my client, he frequents the bars a lot, he drinks a lot, and I go there and we talk, I listen to him, etc. But my position is that both of them came to me, they explained to me what the problems, the circumstances, and then Junior, and by the way, to be total.
But did you ever look at the potential conflicts of interest of you representing both of them?
No, I don't think there was a conflict because both of them agreed to it, Your Honor. I don't see a conflict, and to this date, there's no conflict.
Did you explain and they both agreed in writing?
Not in writing, but I explained to them.
Oh,
I
okay.
talked to them, and she's right here now, Your Honor.
But what does the code require? You know that the rules of professional conduct have specific requirements when you represent someone with a diminished capacity?
Your Honor, at the time I started talking to them, I was not aware of their diminished capacity. After I start hearing these allegations, I am of the opinion that the best psychologist in the Virgin Islands is Dr. Moss in St. Thomas. And I then told him that I'm going to have to get a report from Dr. Moss. And I got a report from Dr. Moss, like on the eve of court, and then I asked her if she could testify telephonically. So, to honestly, Judge, I was not aware of, okay, let me put it this way, because I heard they say he had diminished capacity, but I did not have any documentation from either a doctor.
But then the petition for the emergency hearing for the guardianship, didn't that attach the results of the MRI, Dr. Washer's report that he was in fact suffering from early stage Alzheimer's?
And that's the reason why I sent them to Dr. Moss. After I saw that, I said, well, let me verify, because I think Dr. Moss is the best.
Well, regardless, the fact is that she actually agreed, although she had some questions about whether you can determine Alzheimer's or not. But she
While alive.
Right? But do you realize that the rules, Rule 211.1.14-B, basically would prohibit you representing both parties?
Judge,
that a lawyer with a disabled client should not attempt to represent a third petitioning party who is petitioning for guardianship over the lawyer's, the client's consent?
Honestly, I didn't.
For the lawyer's client, so you seem to just brush that aside, but
I'm familiar with that section, Your Honor, and it's not that I brushed it aside. I can say that now that I'm thinking of it, I didn't think of it at that time. When both of them came in to see me, you know, he and I were joking. I mean, if you know,
testify that she was your client, and you referred to her as your client, and you referred to Mr. Farrelly as your client. So clearly,
for the years that I have known her.
But who hired you? Was it her or was it Mr. Farrelly?
I think Mr. Farrelly who hired me. And then his son came down and confirmed it.
Okay, did the court
went for the first time, and it might even
determine whether he had the capacity to hire you?
If he had the capacity?
Well, if he was suffering under mental...
I don't think that he was that far gone, Judge. I can see him now, and he comes in here, and we sit and we talk. Something that even he still remember, Judge. And I'm going to tell you, when I was 14 years, I worked on the cargo boat that used to come in Frederickson.
I know, I understand all of that, but
no, but what I'm explaining
when he testified, he testified he didn't know why he was there. He identified his wife, but he identified her as Denise. He called her Denise.
He misidentified her.
Yeah, he misidentified her.
Yes,
he actually, but when he testified, neither of you asked him who he wanted to be his guardian. Why wasn't that asked of him if he was testifying?
I think he said that, Your Honor.
Well,
he wanted his...
Can you show me the record where any one of you asked him?
I think he said he wanted.
You think now?
No, he appears to have a preference for the wife.
Yes.
Because she
But I'm
was
saying
then taking care of him.
I understand that's
That's
what
how he
Junior
took it.
said, and that's what everybody said. But when he was testifying, when he was on the stand, could you point anywhere in the record where either of you asked him who was his preference? First of all, did he need a guardian? Did he want a guardian? And who was the preference? Was that ever asked him?
I can't recall the exact words I asked him, Your Honor, but I would have to look at that transcript, which will take a little time. I'd ask that if anything, I can submit if I did at a later point in time, Your Honor, or just give you the citation. But I
Right,
do not.
yeah, just call and give us the appendix, the number and the appendix where that appears, because I haven't seen it.
Okay, I want to make something clear to Your Honor, because I'm an officer of the court, and also, for the first time, when Junior came down, I found out that he is related to me. And I might be putting myself in more hot water but I'm being honest. I was not aware he's a Farrelly. And I even communicating, I did not know that one of the relationship, Iola Roberts, who in my family was his mother, because they all were living in the States. And at that time, after Mr. Junior came down, and he like took over everything, and he said, we related, you know. I said, how we related and everything. I even relaxed more and felt more comfortable. Well, I am going to have to represent. I'm going to represent him.
Attorney.
Yes.
Attorney, remember that the petition, the verified emergency petition for guardianship is dated February 16, 2017. But what is telling is that David A. Wesser's report, the neurologist, his report, and it is there in the report that this gentleman had problems with alcoholism because he used to frequent the bar, particularly after the daughter, Denise was supposed to be taking care of him. She had to leave the island because of medical issues. And when his brother was allegedly put in charge of him, nothing much was happening. That's why when Ivan Jr. came down and see the deplorable conditions that he was in, at this time, I believe that Denise was still off island with her medical issues. But what happened was, of all the people on the big 84 square mile of Santa Cruz, I get the distinct impression that he wanted the ex-wife to take care of him because he knew that there was a feud between his ex-wife, then now his current wife, and therefore between the children and her, even though they might have had a relationship, it seemed to deteriorate it. But there's no question that when he find himself behind the proverbial 8-ball, that he wanted the ex-wife, now the current wife, since he married her twice, he wanted her to take care of him because he loved how she took care of him. It was like in the olden days. But there's no question that at the time of the hearing, at the time of the petition, that he had some, whether because of alcoholism or otherwise, some Alzheimer issues, maybe not as severe as other people, and he was still cognizant of certain things, but she wanted to take care of him because, as she said in her testimony, she still loved him. So,
okay.
But there was no question that he was not the man he used to be at the time of the petition was filed, and that is verified during the hearing and by Dr. Weisser's report.
I agree with.
Just wrap it up, please, because you've gone over now 3 minutes.
My position is that they had justice in court, and my position is that the power of attorney does not give any additional right or priority, and that the court.
But why is that? She had the power of attorney. The statute says if you're a child with a parent with a power of attorney, you have priority over a wife. Isn't that correct?
Because with that power of attorney, she was not here on the island. She was not taking care of him.
The court accepted. Then the court accept the fact that she did have this power of attorney, and that she did have the priority, but that the court had the right to dispense the ranking and make the best interest, make a decision in the best interest of the ward. So I thank you. Your time is up. We'll now return to Tony Russell. You have 6 minutes.
Thank you, Your Honors. And precisely, Your Honor, some of your questions are relevant to everything that happened, because if a visitor was appointed, now, I was looking in my file just now, I didn't receive the order to brief the visitor issue. And I don't have the order, that's okay. But I did raise the issue at the inception of the hearing in March, that the appointment of an independent attorney, and that time was Johanna Manning. And I strenuously objected to the court removing Johanna Manning and having Attorney Winter represent both the ward and Ms. Quinones, okay? So the argument is clear. She had a power of attorney, and more importantly, Your Honors, she had medical issues and she had to leave the island, but it didn't absolve the power of attorney. And the fact is that when Ivan came down and assumed control, and he didn't have any authority to do that. And that's how Ms. Quinones got Mr. Farrelly.
Did he assume control, Attorney Russell, or is it that he stepped in? He was only there for about 4 days to a week. And not that he assumed control, but he stepped in and he realized that his father was not in the best of care. He's made reference to the fact that his father thought that something was wrong because he wasn't getting the type of care from Denise. And he listened to his father and he sought out Lynette at his father's request. When he got to her, and then, like I said earlier, when he saw him months later, almost a year later, his father was in better condition. I mean, that was his testimony. Even if you're saying that there's a dispute between him and Denise being the children of another mother, the point is that this son, who does not live in the Virgin Islands either, felt that his father was in much better care with the wife.
Let me give you a different narrative. The son came down at the request of Ms. Quinones to justify moving his dad from Denise, where Denise had him. There's ample testimony that could be provided, and it wasn't provided, that his care never diminished under Denise. His brother was taking care of him, and his brother was willing to testify, and the court continued the hearing. All of that testimony from Ivan is false, because Ivan Sr. never went through any of that depression or depressed care. That's just hearsay. He said he saw him. He was here for 4 days. In 4 days,
Change the account. He changed the bank account.
Yeah, change the bank account. Do it. And not only that, if he is interested in his father, why not contact his brother who is taking care of him, his family members who are here who taking care of him?
Because Ivan Jr., when he came from the States, he had already made a determination that Mr. Farrelly's brother was not doing a good job in taking care of him, because Mr. Farrelly was becoming slowly towards being a
couldn't provide any evidence of any of that That was just he saying what happened, but people who would testify differently were not present at that hearing. They
Well,
were
Miss
present
Myers
at
was
2
there.
other hearings.
Miss
Huh?
Myers, Miss
Yes,
Myers,
and,
who is the,
and
and
she said,
keep in mind that they're in the same age bracket because she's the
yes,
mother. She's the ex-girlfriend of Mr. Farrelly's brother.
yes. Well, she testified differently. And she testified that Denise was taking care of Mr. Farrelly. And there was testimony to rebut Ivan, who just came down. Ivan has not been involved with Mr. Farrelly's life. And the other sisters who signed the consent and waivers, they were concerned about their dad, why they went along with that.
Yeah, but they weren't involved in his life either. All of them are in Florida and elsewhere.
Yeah, that they call him and they touch base with him. What happened is, as Miss Quinones took over, his family couldn't call him anymore, and they were actually prevented from keeping in touch with their dad. And those people would testify that they would testify that once Miss Quinones took over, she ostracized him from his entire family, his friends, and the environment he was accustomed to. We need.
Well,
I agree.
Attorney, what about the allegations by Ms. Quinones that when she was in the first marriage or during the first marriage, these same children and her developed a acrimonious relationship, and she even suggested that it could very well be because he married her and not their mother. But it is clear that that they didn't enjoy a good relationship no matter what. And she, Ms. Quinones, said that prompted in terms of the first divorce because he would come because there was allegations of domestic violence by Mr. Farrelly against Ms. Quinones in the first marriage due to their hearsay and say. So there's an acrimonious relationship between both sides, the children on the one hand and Ms. Quinones on the other.
Let me explain to you, they're not acrimonious at all. Miss Quinones is acrimonious. Dennis Farrelly and all of the sisters don't have anything against Miss Quinones. Everything you are reciting is what Miss Quinones fabricate. Because Mr. Farrelly...
Well, whether she fabricated it or not, it's in the record, attorney.
But they don't have to be correct. And
but if it's one testimony, attorney, are you suggesting that I should go outside of the record, behind the record of sworn testimony?
Let's go to the record. Remand it for a hearing with the appointment of a visitor, an appointment of an independent counsel other than Attorney Winter, and let the dust settle where it is. Because at that point, at that remand, the testimony will be very different because the daughters who are interested in the dad, they will testify, they will participate by Zoom. This is what needs to be done because the abuse of Mr. Farrelly, because he has a mental capacity by Ms. Quinones, is apparent.
Well, attorney, let me ask you a poignant question. I noticed that everything that you are saying, whatever the other side presented, you always say it's a fabrication, even though it's in the record. And you use that term loosely. I understand that as an advocate, you will never concede or admit anything from the other side. But if everything was a fabrication on the other side, or if 90% of it was a fabrication, the judge heard the so-called alleged fabrication on your part. I'm sure that Attorney Winters would have a different viewpoint, and a decision was made. She had an opportunity, the judge had an opportunity to observe the witnesses. She saw them there, those that testified, including the doctor and everybody else that testified. So, and saw Mrs. Quinones. So I don't think about fabrication for everything.
Okay.
Wait, Your Honor, we want it to be
just wrap it up, please.
Yes, the law, the judge below didn't follow the law. She didn't hold an emergency hearing. She didn't use the medical record to make a determination. She didn't use the access to what all of the information she had to make a fair determination. My client had a power of attorney issued by her
No,
dad.
you're making an argument again. You've had that
Okay,
time.
let me wrap it up. Your Honor, the
time-
suggestion is
All the time has expired.
okay.
The matter will be submitted. And thank you all for appearing, and we'll move to the next case.
Okay, thank you.